I will have to say that based on what's been going on this week, things in the legal arena are getting curiouser and curiouser. That's to quote something from Alice in Wonderland through the looking glass, because everything seems to be revolving around definitions, redefinitions, and new ideas, not to mention new rights, which seem to be being manufactured as we go along, trumping and overriding long established rights here in this country. We have a couple of things going on. First of all, the American Civil Liberties Union is suing the state of Mississippi. On Monday, they announced that the law that Mississippi has that would allow workers to cite their own religious objections to same-sex marriage to deny services to people. Now, theoretically, this is for like wedding cakes and same-sex marriages, but you also have to think about this. Could I, as a Christian, go into a mosque and demand that the imam there perform services for me? Will that be enabled under this type of a thing? How about going into a Jewish delicatessen and demanding that I not be discriminated against, and I want a ham sandwich? This thing has far-reaching consequences, and the idea that people should be forced to override their own conscience to satisfy the idea of somebody else's right is repugnant to much of what the Republic has stood on ever since the founding and the Bill of Rights. Next section is, of course, the dueling lawsuits between the federal government and the state of North Carolina over their new law, which requires that a person use a bathroom which is referenced to what their gender is at birth. And, of course, this is a definition of what gender is, as was the redefinition of what marriage is, etc. But it's beginning to open up a Pandora's box that either is A, curiouser and curiouser, or from a legal definition is dangerouser and dangerouser. Let's talk to Jen Ellis right now. She returns to the program. She's an attorney licensed in federal practice, having represented the State Department and the U.S. Navy, specializes in constitutional law at Colorado Christian University, and does legal on-air stuff for Moody Bible Institute, also author of The Legal Basis for a Moral Constitution. What definitions are we looking at here? Let's start with gender. This is the one that's getting strange, and the odd part about it is we're asserting the right of a very, very small group of people and disregarding the bathroom rights of other people, of a larger group of people. It isn't just providing service to someone. This is getting strange.
It really is. And you really presented that overview very well. And the idea that some of these definitions are not crystal clear is very concerning, not only for rights implications, for privacy implications, but for law in general, because once we open, as you said, the Pandora's box, that we can go back into a law, take a specific word out of it, and then recreate the definition based on an evolving notion in society, really will mean that written law has absolutely no meaning. And that's going to be the end result of what's been put forth by a lot of the liberals here. And so, for example, from the suit that was filed by the Justice Department on Monday against the North Carolina HB2, I'm just going to quote one of the paragraphs from there that speaks specifically to this issue. That lawsuit contended individuals are typically assigned sex on their birth certificate solely on the basis of appearance of the external genitalia at birth. Additional aspects of sex, for example, chromosomal makeup, typically are not assessed or considered at the time of birth except in cases of infants born with ambiguous genitalia. An individual's sex consists of multiple factors. External genitalia are therefore but one component of sex and not always determinative of a person's sex. So they're going back in to this idea of what we have always known was sex, what sex meant, what gender meant. It was always based on external genitalia. It was always based on the fundamental biological differences between male and female human beings, and that was determinative of a person's sex. Going back in, and as the lawsuits contend, gender identity, which is an individual's internal sense and a subjective sense of being male or female, that subjective component can now impact something that has always been empirically determinative within the law is really going to create a lot of ambiguity. It's going to have far-reaching impacts not only on these types of issues, but for the law as an entire discipline.
Yeah, because theoretically, when people at a legislature or at Congress write a law, they understand words to mean certain things. Quite often, definitions are provided in the course of a law. And what they're trying to do is change the definition and then read the applicable part back into that new definition. As you say, at that point, words don't have meaning for us, except as they're meant to mean at any given moment in time, which puts us all on a real shaky deck.
Exactly. And so what they're trying to do here, what the Justice Department is trying to do, is redefine our understanding and specific meaning of the term sex and go back in and allow that definition to control the 1964 Civil Rights Act definition, which deals with discrimination. And you can't do that. That's something that is fundamentally antithetical to all meaning in law, how lawyers litigate, how we practice law, and certainly how Congress and those who legislate establish the law. A law means what it means. A contract between two individuals. Definitions, as you say, are typically provided up front if there is any concern for ambiguity, and those meanings control. If you want to go back in and change the law, you have to do that by taking the original meaning and then overturning that law in a constitutional or legally appropriate fashion. It's not at all the appropriate way to go back in and simply say, well, we want to change the Civil Rights Act definition of sex, so we're going to change the normally accepted meaning and then therefore impute that into the law. That destroys all notions of acceptable litigation practices, and that we can, as a citizen of a society, have any sort of comfort that we're actually protected by any laws. What's to change in the future the DOJ or any part of the executive federal branch from going into state law or federal law that protects and preserves our fundamental constitutional rights and simply changing a word to mean whatever they want it now to mean? And that's even worse than the exorbitant and ridiculous overreach of the Supreme Court. This just takes it to an entirely new level.
But of course, if you go back in the history of progressive thought, I talk about progressive elites rather than just liberalism, because there is a difference. But the progressive elites have always played the game on the basis of make a definition, jockey people into it, and then if they don't go along with it, then of course the attack goes against them. And this happens from item to item. This is nothing new, by the way. We've just hit new heights in where we are right now. And they don't really care, it seems like, if we destroy the notion of law as we go. Remember that in the former Soviet Union, I always say the difference between a free society and a totalitarian society. In a free society, the laws are few and clearly understandable. In a totalitarian society, they are numerous and vague. And that way, anyone can be guilty when they have to be for any particular circumstance. In other words, it's not clear. And you're right. You have no feeling of protection. But let's talk about protection. We have the ACLU suit going, the Mississippi ACLU, against the state of Mississippi over their law, which enables people of faith to say, I can't participate in what you are doing right now because of my religious belief. The redefinition, if you remember when President Obama came into office, he talked about freedom of, what was it? Worship, not freedom of religion. And religion is much more over-encompassing, where you have a right to live according to the tenets of this religion. That's one of the oldest rights in the country. But now we're being told it must step aside in the name of all these new rights. So what about this? Because theoretically, these bills say you can't discriminate on the basis of religion, but when it comes to religion versus same-sex rights, it seems like we can.
Right. And that's really become the contention, is to say, okay, then whose rights trump in that situation? If you have someone saying, I want a religious freedom exception to not participate in an activity, and then a same-sex couple says, but I want to have the protection of not being discriminated against. And so typically, if the law is functioning correctly and according to our Constitution and our Bill of Rights, the difference there is to say that it depends on who is doing the infringing upon whom. Because, for example, if an employer is saying, I am not going to employ you on the basis of your sexual orientation or on the basis of being same-sex married, they are doing the infringing, and that is unlawful. But according to the First Amendment, when it's the same-sex couple who is seeking to compel a baker to participate and to actually extend them a service, they're the ones who are actively seeking for that baker to then be compelled against his religious practices and his sincerely held religious beliefs. And so what the liberals are trying to do is equate the two and essentially say we are going to allow the same-sex couples to say that their compelling of a religious individual actually trumps their own right to freedom of religion. And so they're trying to give all of the cards, all of the protection only to the same-sex couple, rather than having protections equally distributed among individuals depending on the type and way that the infringement is happening. So what they're doing is very clever, and it's basically the logical fallacy of a false analogy. They're trying to equate two different circumstances and say that they are legally identical and constitutionally identical, and the simple fact is that they're not.
But we already have precedent, and I'm sure as an attorney you could do better than I. We have precedent for allowing certain things on the basis of religion, vis-a-vis, say, for example, the draft. We made exemptions for people who had genuinely held religious convictions, say Jehovah's Witnesses or Quakers or others, who believed that they should not be serving in the military. Even though the law said all young men have to do this, we made an exception on the basis of these people's religious belief. We already have precedent for that.
Absolutely.
Look at Lakewood, Colorado. There was a bakery that was involved there in Colorado where you are. Can you tell me that a same-sex couple can't find a bakery in Colorado to bake a cake?
Exactly.
This is not like they can't. I wouldn't expect to go into a deli and want a ham sandwich. I wouldn't go to a mosque and demand that he perform a wedding for me or something else like that. Why? Because that's repugnant to their faith and it's unkind of me. I respect that right. But that seems to be going out the door here. This seems to be a winner-take-all, and that's where I think the danger is, because if we keep going down this road, society's going to look really bizarre after a while.
It will. And what you had said just a few minutes ago about the progressive elites using the changing of definitions to advance their agenda is absolutely true. I mean, any policy debater understands that the first thing you do at the beginning of the advancement of your particular policy to affirm that is to provide your definitions. And if you provide definitions that then the other side either fails to negate or they accept, then you'll win. Regardless of the merits of the case, regardless of anything else, he who defines his terms in the way that is most favorable to their side generally will win.
Let's do a break right now. Jenna Ellis is my guest, constitutional attorney, and under discussion, the incredible distortions we're building into our law. We're at steelonsteel.com. I'm John Lufter. The reason I'm doing this program today the way we are, because this is an issue that everyone's covering, is we have these little spats going on in different states over a seeming crusade on one part for more people's rights. But if you've noticed, we've come a long way from the original founding. Welcome back to Steel on Steel. John Lufter here with you, which is to be expected. I mean, time goes on. In the original concept of rights, as they were written into the Bill of Rights, these were limitations on what government could demand of people. And the people were on one side, government was on the other. The purpose was to enable the maximum amount of freedom that the people would thereby enjoy and to be left alone, except only insofar as necessary on the part of government. That's how the original rights were set up. Now, if you have noticed, we have shifted, and we have shifted to a point where the rights are pitting one right against another and pitting one group of people against another. And the progressive dialecticians just love it because it creates that Saul Alinsky back and forth friction, which lets them achieve a large number of their goals. As people are focused individually on each individual point, they fail to notice what's going on a large scale.